Hello, everyone, and welcome to the Virginia Legislative Update for the Washington Metropolitan Chapter of CAI. We will be doing a PowerPoint presentation for you, and then when we are done, we will take questions. So please let us know what those are when we get to the end. I'm Amy Kessler. I'm with Segan Mason and Mason.
And I'm Bill Marr with practice in Fairfax, Virginia.
And we are the co-chairs of the Legislative Committee for Virginia for the Washington Metropolitan Chapter. Cameron, can you go to the next slide?
So we're going to review with you, give you an overview of the 2025 session. This session started January the 8th and finished up February the 22nd. It's what's called a short session of the Virginia legislature. Ordinarily on the odd years, you have a short session, generally around 45 days, and then in the even years, you would have the longer sessions. Those sessions are generally followed by a period of time in which the bills that have been passed are considered by the governor, and then there's basically a follow-up session after the bills have been passed for veto or other action. We've included in the slide here a breakdown of overall some of the session numbers of bills introduced and passed. I'm going to just spend a little bit of time kind of going into a little bit more detail. Before I get into that, I will point out that roughly 40 of the bills that were introduced were monitored by the Virginia Legislative Action Committee. We'll talk a little bit more about the role of the committee later on, but of the bills that were introduced, and there were a total of, actually between the House and the Senate, there were a total of over 3,000 bills introduced between the two houses, 2,000 in the House, and then approximately 1,000 in the Senate. Of those bills introduced, 1,275 of the House bills passed, and 714 of the Senate bills passed. The failure rate in the House, the number was approximately 947 in the House, and then in the Senate 511. So what you generally are seeing there is almost a 2-for-1 split. Almost twice as many bills introduced in the House as the Senate, and twice as many bills passed as in the Senate. So a lot more of activity in the House. Part of that is because of the nature of the legislation, and one of the things that's kind of unique, and particularly when you've got new legislators, and there has been a lot of turnover in both the House and the Senate, and there's going to be some more of that as a result of elections that are coming up later this year. But one of the things that is a little unique is if there's legislation that's introduced and it is considered to not have a financial impact directly on the state, then it's much easier to get the legislation introduced. It does not require a financial review or financial a report to be done. So the legislative service is more apt to go ahead and bring that, get bills written and are more readily introduced. And so you see that reflected in the numbers, particularly I think in a short session, and more apt to see that specifically in the House. So we tried to break down a little bit as far as what happened in this last session. And as I mentioned earlier, there were about 40 of the bills that were monitored by the Virginia Legislative Action Committee. We're gonna talk about the bills that were passed, and we're going to talk about some of the bills that did not pass, and some of the bills that were referred to what's called the Virginia Housing Commission for further study and evaluation. So with that, we'll go ahead and go on to the next slide and discuss one of the first bills that was introduced. Amy?
Yes, this one was, well, every year it seems the legislature needs to mess with the Resale Disclosure Act, and you can see there are going to be two bills we talk about in which this was taken up. One was this one, which ultimately was passed to say that there has to be a line in the resale disclosure certificate that says if an owner is going to be responsible or not for the insurance deductible. It has to basically warn them that that's a possibility. This is something you probably won't see a lot in HOAs because the master insurance policy is covering the common area. So that's less of an issue. But in condominiums, frequently the master policy has a deductible that then the unit owner may or may not be responsible for, depending on the situation with the issue. Typically, a leak would be the greatest example of that. And so they just wanted to put people on notice. Originally, I believe this bill wanted the associations to actually say, will you be responsible or will you not? And pretty much all of us stood up on the rooftops and said, there's no way in God's green earth we can do that because it's very document and fact specific. So instead, they kind of moved down to the second level of just letting people know that that's a possibility out there.
So this, just a little bit of background on that. The House bill was introduced by Delegate Bulova, who's also chair of the Housing Commission, and he frequently proposes legislation that impacts our industry, so to speak. And by a little bit further background, the Resale Disclosure Act is the latest statute that we who are involved with the industry have to deal with. As many of you may recall that one of the principal reasons for the Property Owners Association Act, which was passed back in 1989, was to create a disclosure requirement for sales in HOAs and POAs. Had already been was already in the Condominium Act, obviously, but there were a lot of realtors and others who were concerned about the fact that there were not disclosures related to the sale of properties in POAs, and so the push to put the POA Act in place started in large part because of the disclosure requirement. So we now fast forward, and as most of you know, the Property Owners Association Act from 1989 coming forward been amended pretty much every year since then. Well, there was then a push, and in part again from the realtors, that there was concern that both with respect to property owner associations, condominiums, and co-ops, there needed to be more uniformity in the nature of the disclosures. So thus comes about the Resale Disclosure Act, which basically takes all three types of entities and brings them under one disclosure act with one basically set of disclosure sheets. So that's sort of part of the background of this whole thing, and and as a result of that, when we are looking at what impacts us as far as our industry and what impacts us as far as our requirements, you can't forget about the Resale Disclosure Act. I've occasionally run across associations in other parts of the state, in many cases self-managed, to say, well, I thought it was okay if we just gave them the documents, and that obviously not, but and that's a far cry from the way things are handled here. But
Right.
but nevertheless, it's important to keep in mind that you're really, when you're dealing with, well, if you're dealing with POAs or HOAs, you're dealing with generally non-stock entities. You're dealing with the POA under the Act, and then you have to look at the Resale Disclosure Act as well. So it's important to keep all three things in mind as you go forward.
And if you look at the next slide as well, this is the other change to the Resale Disclosure Act. It kind of makes it explicit that the association can't require a purchaser's name before preparing the resale certificate. And the reason for that, from the association's perspective or from the seller's perspective really, is that maybe I want to get a resale package before I sell my unit or before I put it on the market. So I know everything I need to know to then prepare it and have it ready to go on the market and sell quickly. And I won't necessarily have a purchaser. The association's perspective and management's perspective is, how do we know who to give an update to if an update's requested later? Because a purchaser can request an update. So how do we know who to give the update to if we don't know who the purchaser is from the beginning? the statute itself, 55-1-2311, says that you can give it to the purchaser upon proof of being the contract purchaser. Of course, that's a question too, right? Because what exactly are we going to require? Theoretically, a copy of the contract, but then what if there are two contracts and one's been terminated? The association's not in the position to know. So we're going to kind of have to see how this one plays out practically to see if we need to tweak it next year, because if the realtors can play with the Resale Disclosure Act, why can't we?
Yeah, and I think, this probably less of an issue here immediately than in some others, because frequently these matters are handled through management.
Exactly.
But with some of the self-managed communities, and there are some in the Northern Virginia area, but throughout the state, you're lucky to get somebody to go ahead and provide the disclosure and to get into some of these kinds of issues and how things are going to be paid for and so forth. Is a legitimate concern. So I think there's a real educational process that has to take part in order to make sure people fully understand exactly what's expected and then how they go about complying with these requirements.
Because we all know this is a huge asset for people, and when they're selling their properties, they're very concerned about every little thing. And of course, everything's an emergency. So we definitely need to be on our game to know what we're doing on our end legally so that we can set it up as best we can for the sellers and the buyers.
Yeah, and the thing I've seen recently, last year and a half or so, in some of the markets, and not certainly some in Northern Virginia, but some other in Central Virginia and other areas, is that as soon as a home goes on the market, there are multiple contracts in place, backups and that sort of thing. So then everybody wants to know everything, and that then becomes an issue in terms of what you have to provide, who you have to provide it for, and how much information is disclosed.
Absolutely.
Yeah.
Great point. All right, if we go to our next slide, you'll see there were two bills introduced about management companies. One was to kind of add a layer to what's required to be turned over. There was statutory language requiring managers to transfer books and records, but now they've explicitly added funds and bank accounts within a reasonable time. Again, I think this is something most management companies handle pretty well, but of course there's always the issue of smaller management companies, self-managed, going to manage, that sort of thing that becomes complicated. So, but the kind of the more significant section was, if you remember, I believe it was a year ago, they they added a statute that said if your management contract has an automatic renewal provision, you could terminate it within 60 days with 60 days notice. This was tweaked this year to add this without penalty language, because the idea was that apparently some community association management companies were still charging the contractual penalty for early termination and allowing them to terminate within the 60 days. And the legislature said, no, we meant that they could do it within the 60 days notice, but also without penalty. They don't have to pay those penalties.
Yeah, we've had looked at a couple contracts within the last 6 months that still have that penalty provision in there. So I think that's impetus to go ahead and get that.
If we could just get this to apply to trash contracts, I think, and laundry contracts, our lives would be a lot easier.
Well, we're going to talk about trash.
We're going to get to trash. We're going to get to trash. So that's it. So if we could turn to the next slide. This is an example of something that doesn't seem to, I mean, it obviously impacts associations, but it's not directly related. This isn't just association cases. This isn't just association work. But they changed the jurisdictional limit in the general district court from $25,000 to $50,000. What does that mean to you as an association? Well, if you are suing for something that is a larger amount than $25,000 prior to July 1, you'd have to go to circuit court and file that suit. And that can be problematic in terms of cost and time, because circuit court is much more procedural. So it takes much longer in the whole process of getting through a lawsuit. And it's more expensive because there are many more steps. So the lawyers have to file more things. And there's also more potential for an attorney to be hired on the other side, request discovery, those sorts of things. And also the possibility of a jury trial. But if we're in general district court, it goes a lot faster. It is a lot cheaper because there aren't as many steps. There aren't jury trials in general district court. And so these issues can be addressed in a much more economical way for the association and a much speedier one for a higher level of money. The flip side of that is it's not just increased as to associations, it's increased to everybody.
Right.
So we're going to see an increased volume in general district court because now everybody can go up to $50,000, and those cases are going to come down from circuit into general district and cause more dockets, more trials, more everything. So that could be problematic and slow it back down the other way,
right.
Because now the courts are more crowded.
So they actually this change was made to apply to all civil actions in general district court. There has been a $50,000 jurisdictional limit in general district courts, but it only applied to personal injury and wrongful death cases. So they tried that on for size, decided it worked, and so they've now expanded the jurisdictional limits for all cases. And as Amy has said, one of the things it does mean is that you're going to get a lot more action in general district court, a lot more cases. And as I'm sure some of the other attorneys and managers who are listening today can attest to, the general district courts have gotten somewhat crowded, and the courts are setting limits on the number of cases that they will handle, limiting the number of cases they will allow an attorney to handle on any given day. So this I believe is going to expand that issue considerably, and I think it requires a lot of cooperation and heads up, particularly between management and council, so that you can go ahead and have enough time to plan out your docket several months ahead of time. Where if you're trying to get cases filed today and you're going into Fairfax, you're going into Prince William, and they're talking about dockets out to 3 or 4 months out. That and those are return dates. That's a long time, and obviously those are outstanding cases, but those are delinquencies that show up on your monthly reports and are of concern to your members. And when it gets to be annual meeting time and people are looking at some significant delinquencies, those are concerns. And it's to some extent, and obviously folks who've been doing this a while realize how much of a change it's been, I'd say, since COVID.
Yes.
Because there were staffing issues, and then a lot of things got deferred and delayed. So at any rate, all of those things combined means that we've got the dockets are full, the dockets are busy, crowded, and have been pushed out. So with this increased jurisdiction limit is having a significant impact on how cases are going to be handled.
And this is actually a great time to talk about the difference between the LAC and the Legislative Committee, just briefly, because what the LAC does, the Virginia Legislative Action Committee, is statewide. That committee is put together by CAI National with a mix of homeowners, business partners, managers, whoever. And their job, that committee's job, is to review the legislation and try to get out in front of it. Sometimes if it's bad, support if it's a good. Talk about the impact if it doesn't seem like it directly relates. Like towing is a great example, right? Like we're towing legislation proposed last session, and it was like, does this affect us? Doesn't it affect us? How can we change the language? We're working behind the scenes to make sure that stuff gets taken care of, and that's at a state level. But then this gets passed at the state level, and then here we go, the Virginia Legislative Committee. We're looking at Prince William and Fairfax and Loudon, all the areas in our chapter where let's see how this is going to affect it. Prince William a couple months ago issued a limit to how many cases would be heard on their dockets. That's based on the current caseload, right? So right now, let's say they have 1,000 cases a week. They want it split up a certain way. Well, great, except now your cases are going to increase, and now your caseload is going to be nuts. And we have seen it where we have to set cases into November in June because of the limitations on schedules from the courts. So this is a real concern, and this is something that the Virginia Legislative Committee, Bill's in my committee, is addressing and trying to get boots on the ground to deal with. And you're going to see other issues later that we're going to talk about that are more local-based issues that the LAC doesn't care about, so to speak, because that's not their area of expertise and their bailiwick. Our bailiwick is more local. we certainly report up to the LAC and say, hey, we're seeing this issue, we want this concern addressed, that sort of thing. But really, the legislative committee is here to try to address more of the local issues and the impact of some of these decisions that are coming out of Richmond.
Great.
All right, let's move on to the ones that are not with us but are coming back. So, like vampires, will they rise again?
Yeah, I think we've got. We're going to talk about House and Senate bills that relate to common interest communities, but were not passed in the 2025 Legislative Assembly. These bills may be renewed at a later date. There are a number of ways that legislation can kind of be killed or die, left in committee, not reported out, referred to the Housing Commission, and we'll talk about a couple of those as we go through this process. But it's an interesting it's an interesting process that goes on down in Richmond, and it's something that it takes a while to understand. And
if you can understand
it, and it's you need to have a pretty clear understanding of the players and how things function. And
everything comes from somewhere.
Everything comes from somewhere, and Northern Virginia is considered you're way up there, and you got your own problems. And you don't,
right.
In some cases, they don't want them down in Richmond.
Right.
The first one we're gonna talk about is the bingo case, or not bingo, the bingo legislation. This is something that we closely monitored, and some of the other local jurisdictions in Northern Virginia, for example, like Reston, have also closely monitored it.
This was actually the bill that we were most amused by at the LAC level. This caused quite a bit of laughter, and you'll see why when Bill tells you about it.
So this provides that common interest communities that serve residents of age 55 and older may become qualified organizations, which is a term that's necessary under the gambling legislation for conducting bingo pursuant to the rules and regulations of the Department of Agriculture and Consumer Services, which is where the gambling is handled. I mean, I guess you've got to be 55 or older to understand what you're doing. But anyhow, that was one of the requirements, and it would be limited only to the members of the common interest community, and be conducted for no more than 7 days a year. Again, kind of an interesting concept of why 7 days and members only kind of thing. And then they would place value limits on the prize money and merchandise that have not yet been established. And of course, the other aspect is, like with other things, is whether or not there's any ability with respect to taxing and reporting requirements. And that's, as you deal with things, for example, the RBO and some of the Airbnbs and Bs, the thing that gets local jurisdictions excited and interested is the possibility of taxes. So there are pieces of legislation, and this had some legs and died, and it will be back this year. But part of the reason for that is that I in those possibility of taxes.
I agree, and I think, what's so amusing is, of course, I was telling my daughter about this. She's 14, and she was very angry to determine that she could not participate in the bingo game. So we're not clear on. Obviously, it came from somewhere with these specificities, but we're not really clear on why 7 days, why only over 55. And there was also a part that said you had to pay part of the money taken in to a charity, but the association's already mostly a nonprofit. So why? There was a lot of things that just didn't make sense. So this didn't get far enough for us to get a lot of those questions answered, but hopefully the patron will take it back and kind of try to figure out how to adjust the bill to get there.
Yeah, and I don't think this went to the Housing Commission.
No, I don't believe so.
No, I think so. This is still sort of out there, and it'll come back.
Yeah,
it'll
come back.
And I think there needs to be. So it'll be coming back into a long session. So I would expect there's going to be some activity on it starting pretty soon this summer.
Yes, absolutely.
Yeah.
Absolutely.
So,
all right, our next issue is conservation landscaping. There's I don't want us to be too negative about this. I understand the purpose behind this is largely an environmental one. It's like the butterfly gardens you'll see on the public streets where they'll have areas where it says "Do not mow, butterfly area" and that sort of thing. But the concern is multi-leveled, starting with we have guidelines in our associations of what is maintenance and how you take care of your property. And is the picture on your right maintenance under anyone's standards?
Yeah, I think if you look at some of the, obviously a picture here is worth at least 1,000 words. And if that were the same community, somebody's going to be very upset. The bill would create a new statutory provision in the Property Owners Association Act, managed conservation landscaping, unreasonable restrictions prohibited. So that's that's the important language there. Unless expressed in the declaration, management, conservation, landscaping may not be prohibited. And an association may establish reasonable restrictions concerning the management, design, and aesthetics, keeping all that in mind. Managed conservation landscaping are their landscape practices that include the following. Landscaping designed to increase water quality standards and reduce pollution in Chesapeake Bay total maximum daily load limits. Landscaping designed to protect clean air and water. Landscaping designed to support wildlife and prioritize native species. And landscaping incorporated rain gardens and other features to reduce need for irrigation. Managed conservation landscaping is not turf grass lawns left unattended, a la the picture on the right.
But it could be a wildflower garden that is designed to attract butterflies and bees to increase that.
And the unreasonable restrictions, which we referenced earlier, include restrictions that significantly increase costs, restrictions that significantly decrease the effectiveness of the landscaping, restrictions requiring cultivated vegetation or turfed grass, and restrictions prohibiting landscaping in front or other visible areas of property. Finally, restrictions limiting landscaping to a specific percentage of property. So those are all considered unreasonable restrictions under this proposed legislation. And the goal here is, regardless of what you basically got in your recorded documents or guidelines, this would the idea here is to override all of that, and that's obviously where we have a significant problem.
Oh, absolutely, and also there's no consideration taken into the different kinds of communities you have, right? I mean, I think we'd all be a lot more comfortable with a wild butterfly garden on a single family property in, say, Percival, where they have 2 acres.
Right.
As opposed to a townhouse in Fairfax City where, you have people next door and the bees are attacking you, right? So, I mean, there's a lot of issues there. And also the fact that not the limitation on keeping the conservation landscaping out of the front that they find unreasonable is very interesting, because I think that would be a lot of associations' kind of first thought. Like, sure, go ahead, do it in your backyard,
right,
but not in the front where everybody can see, because we have multiple properties to deal with, people walking by on the sidewalk. So, I mean, I think there are a lot of issues to be dealt with here, because it's overriding contracts that are already in place,
right,
and because it's treating every property as the same. I mean, forget just Northern Virginia. I mean, there are farms in rural Virginia. That's a totally, they may not be part of HOAs, right? But yeah. I mean, there are so many different issues that can be dealt with here that are not being addressed in this conservation landscaping movement. And there are a lot of people who are very supportive of it and have a lot of interest. And I think we really need to have a way to come to the table and have a conversation to address both sides, which is not what we've had yet.
Yeah, and how I guess the other consideration is how, in light of all of this, how appropriate is this kind of legislation on the detailed basis that it's being provided in a community like Fairfax? I mean, that's a very real question, and I think fortunately this legislation has not has not moved forward. It has other jurisdictions. It has in Maryland.
Yes.
But again, it will be back. It's been studied and looked at, and it will be back again this
Oh,
coming
absolutely.
year.
Absolutely. No question. All right. Our next slide is about everybody's favorite, ham radio. Ham radio, which I only remember from the 70s being some sort of like CB backwater, everybody talking in secret thing. And apparently it's not. And breaker, exactly. And apparently it's not. And my understanding is, I mean, the issue, there are many, many issues with ham radio, but number one is, again, this one size fits all thing, right?
Right.
Because again, my townhouse that I owned in Annandale had a yard the size of this room. Putting a giant antenna on that, or any antenna on that, is one thing, as opposed to my single family house now, which has, like a quarter of an acre. I mean, these are different issues that need to be addressed differently. And again, this legislation, like the conservation landscaping legislation, has, unless it's expressly prohibited in the governing documents, HOAs have to allow these antenna, and not just allow these antenna on lot owners' property, but on limited common elements and potentially common elements.
So just to go through what it would require, this is HB 2542, which was left in committee, and we'll talk a little bit more about that in a minute. It would provide new
Everybody, the ham radio people took us out.
Okay, it was a conspiracy. We've persevered here. So going back over what the proposed House Bill 2542 would do, would provide new statutory provisions in the Virginia Property Owners Association Act, the Condominium Act, and the Real Estate Cooperative Act. No declaration or condominium instrument recorded after July 1st, 2025 may prohibit the erection of a ham radio antenna for the owner's personal use on the property owned by the land or unit owner. So that would prohibit any restrictions from a declaration or instrument.
Okay, so let me just jump in.
Yeah.
So owned by a unit owner.
Right.
Unit owners, all unit owners as a group own the common elements and limited common elements in a condo.
Interest.
So there's your weird window. Now we have ham radio antennas that can be built on balconies and roofs and all sorts of stuff at condominiums, according to this legislation, we can't prevent it, because if it's not in the declaration or condominium instruments, we can't stop it.
Well, as written now, it says on property owned by the land or unit owner.
Yeah.
So a unit owner doesn't, other than the interior of their unit, they have an undivided interest in the common elements, and they may have exclusive use of a common element as in a limit common element, but there's no more ownership interest there. So I'm not sure this gets them to where they need to go. And I think,
well, but that was the concern, right?
Right.
How is that being read, and how is that going to be applied?
And as I mentioned, the issue has been brought up with the Housing Commission, and that issue focused around antennas. That really being the issue: where are you going to put these, and how are they going to be maintained, constructed, impact, and so forth. Another part of the act was an association may establish reasonable restrictions as to the number, size, place, and manner of placement of the antennas for the ham radios, very similar to what was done with respect to TV and reception.
Right.
An association may require preconditions as follows: detailed plans and drawings from an engineer familiar with ham antennas, proof of compliance with local rules and ordinances and safety standards, requirement that owners shall maintain the antenna in a structurally safe condition, requirement the owner pays for installation and maintenance, visual screening requirements for enclosures and guy wires, and requirement that the owner shall pay for costs and removal upon sale.
So like electronic vehicles, really, is
Right.
what we're looking at.
Right. So those were the contents of the proposed legislation. Again, this was left in committee, was not, but has since been has gone to the Virginia Housing Commission work group, and that work group, chaired by Delegate Bulova, David Bulova, the chair, has, in their May meeting, they did look at the amateur radio antennas. Actually, Pia Trugiani, who may be with us today, but she testified at that meeting, and I think that the substance of what happened there was the concern that's been raised about putting these antennas. In the case of condominiums, you don't have a unit owner that has property where it could be put on necessarily, and then the obvious issues with putting what may be a 30 or foot antenna on either on common area in a POA or on an individual lot, and the impact that may have. So this legislation has been raised and come up a number of years. There are people who will argue, well, the technology has sort of bypassed the need for ham radios, the Starlights and some of the other systems that are available that are easier to establish and utilize. So, but nevertheless, this I will say you have to admire the ham radio folks for their persistence.
Yes.
And at this rate, we will see legislation once again this year.
Oh, absolutely. And our understanding is that the ham radio lobby, which is nationwide, has not gotten anywhere at the federal level. So they have used their resources in Virginia to try to get legislation passed here. And my understanding also is during some of the recent hurricanes, North Carolina, that sort of thing, and in Virginia, that the ham radio operators were very useful. Right. When technology went down for various reasons. So that they have some
completely legitimate non-fund uses, right? But the issue again is we go back to every unit is not the same. Every association is not the same. And, you know, what is a reasonable restriction? If I as a townhouse community say, you know, 3 feet is a reasonable restriction, can the ham radio operator come back and say, but my ham radio antenna has to be 30 feet tall in order to do what I need to do? So some of that is very fuzzy, and we want all that clarified and specified more before we would even consider supporting it.
So I think because it has gone to this work group and is part of the Housing Commission, I think there will be more opportunity to investigate the situation and see if there are accommodations that can be made that meet the necessary requirements. But I think the big stumbling block appears to be obviously the antenna,
Yes.
where it goes, what's going to be the ability to actually construct that, and where it's going to be placed. So
Exactly.
stand by for more. The Housing Commission meets in July, and I think this should be on the agenda. There are actually a couple of other related issues that came out of the Housing Commission. One of them is something that most of us who are dealing with communities that are well established are do not see as a problem, but there are communities throughout the state where declarant control of residential developments and the process for transitioning control to lot owners is a real concern. As most of you know, generally in the condominium setting, there is a built-in declarant control period, statutory and through the declaration. Frequently not the case in HOAs and POAs, and that is an area of concern. Declarants, developers concerned about giving up control too early while they're still trying to develop. Owners concerned about things not getting done soon enough, or issues being addressed and wanting to have the ability to address them. So that is an issue that the Housing Commission work group is looking at. We're also we'll be monitoring that, and as I said, their next meeting will be in Richmond in the middle of July. So the one other it's kind of an interesting issue that the Housing Commission is taking a look at is the right of first refusal. So many of us who've been practicing for a while looked at the old documents, and they contain rights of first refusal with respect to limiting, groups of people. Or I guess one of the worst I saw was a community over on the Maryland, on the Chesapeake, and they had limitations on people buying in who didn't have at least college degrees, preferable a master's degree, and then a right of first refusal built in around that. But beyond that, the new idea or the use for the right of first refusal is that there are entities that are looking at including that in certain documents, where they're looking at the affordable housing stock and looking at the ability to be able to go in and on a first refusal basis pick up lots if they see that as to be appropriate or necessary. I don't think this has been fleshed out completely. There has not been legislation, as far as we know, that has been introduced to deal with it, but it is an issue that is on our radar now, because it is something that I think we will be seeing. And obviously the issue becomes, does it impact our communities now? Does it impact documents now? And what's the intention going forward?
Right, absolutely. So we'll have to keep an eye on that, but that's not that we don't keep an eye on that at our level, but it is a LAC job to keep an eye on what legislation's out there, what's coming up, and try to work to get it in good shape before it even gets to the General Assembly next January.
Right. So we do have
one exciting local issue. I know you're all thrilled. You can go to the next slide, Cameron. This is all about trash. This is Fairfax specific, but who knows where it'll go next or what will happen next. So basically the county wants to eliminate private trash collection
Right.
and make it so that the county is divided up into various districts, and each district has the contract for it awarded to a trash company.
So they're calling this the proposed unified sanitation district in Fairfax County. It was scheduled to be heard in front of the Board of Supervisors, having worked its way through, in part through staff and so forth, July the 24th.
June.
I'm sorry, June the 24th. And now that has been rescheduled to October, I think.
Correct.
So in the meantime,
We're not the only people hot and bothered.
yeah, we've looked at it. And there are a number of issues related to it. We have been able to deal with and had some good help from the waste management community, and Brandon Cook and Jeffrey Porter have both been on top of this on our committee.
Absolutely.
And given us some good information. We have prepared a letter from the committee to the county through the board of directors of CAI of our chapter. That has been signed off on by the chapter, apparently unanimous consent of the board of directors, and that basically we are taking a position of great concern about this and some opposition. So we are also working with some of the local folks who are involved, and supporting their efforts to try and get the real issues in front of the Board of Supervisors. Just briefly, I'll touch on a couple. With respect to this sanitation district, would necessarily create the loss of local control and service flexibility. Fairfax would have a single source at this point. Cost increases without service enhancements are likely. Service quality and accountability would be difficult. Disruption in existing contracts, because many of you may have long-term contracts that could be impacted by this.
Absolutely.
And those are just some of the concerns that have been raised and would need to be adequately addressed and have not been thus far. So,
and not to sound like a broken record, but again, we're back to one size fits all, right? I mean, a townhouse community needs different collection than a single family community. And that's just in terms of provision of cans and frequency of pickup and, those sorts of things. And who is going to address that? I mean, if you hire ABC Trash Company for the Fairfax city environs, right? I mean, so then that's a million different communities,
right?
And each one is having trash picked up in a different way, and the responsiveness level may be different in all of those. It's also understanding that there will not be multi-week pickup, that pickup will only happen once a week, which would definitely impact a lot of our associations greatly.
Yeah, one of the things I find interesting, having been practicing in Fairfax for many years, is that way back when associations were still being new and being created, and why do we need them and so forth, the pitch that the county was dealing with, well, we're glad to have you because now we don't have to worry about your roads and your snow removal.
Exactly.
And we don't have to worry about your trash because you'll take care of it and you can assess your members for that. And now they've kind of decided to flip this thing the other way, because I think at present the county, Fairfax probably they do about 10% of the pickups.
That's our understanding.
And they've been doing that, and that number has gone down as the number of communities have increased and therefore providing their own services. So here we are now, and they're deciding to sort of go back the other way.
And again, we're in a situation where we're really not quite sure what problem they're trying to solve.
Right.
Because I don't know why the county would want to control this any more than they already do, especially considering they have such a little piece of the pie in terms of actual trash pickup. So we're trying to get more information, but you go on any of the news websites, the TOP, NBC4, all of those, the paper, everybody is commenting on this. And like I said, it's not just us. It's individual unit owners, it's the trash people, it's everything, because we all want to be able to control our own situations, and this is imposing control without any real benefit that we can see at this point.
So I think one of the things with the folks who are on today is that if you've got experiences or if you've got interest in your communities that you work with or represent have interests, we would like to know about that. As I said, we've prepared a letter that is being sent to the Board of Supervisors. We are supporting some other correspondence and some other actions being taken, and we'd like your support and input directly or indirectly. And so if you can take the time to, either let us know, hey, I've got a community that feels very strongly and so forth and so on, that would, or somebody that has a position, we would certainly like to know about it and be able to go ahead and communicate that to the Board of Supervisors. As
Absolutely.
I said, that meeting was supposed to be later this month, June the 24th, and it's now been pushed back to October. So we've got some time to deal with it.
Yeah, and we're also probably going to need people to testify at that October meeting.
Right.
And I mean, Bill and I think we're really important, but attorneys don't matter when it comes to legislative bodies, right? So
constituents.
Yes, the Board of Supervisors and the General Assembly don't want to hear what we say. They want to hear what people who are actually living these experiences say. So, we want to hear from boards, we want to hear from homeowners, because that's what's going to matter to them, not what we say as lawyers. So please take that into consideration and reach out for us. I think both of our email addresses are on the CAI website,
right,
as the co-chairs of the legislative committee. So feel free to email both or one of us, and we'll take care of it. And then we just wanted to let you know, the Virginia Legislative Committee, we want you to participate. We want you to come out and share your knowledge and get information from us. We meet the third Wednesday of every month at 11:30 a.m. via Zoom. And that's intentional. I mean, as much as we'd rather meet in person, we think it's way more convenient and way more participation when we meet via Zoom. And we want to know, if you want to let us know in advance, you have an issue you want to discuss, if you have a problem you want to bring, whatever. We really want more participation, because we all have different perspectives. And what matters to a manager may not matter to a lawyer, may not matter to a homeowner, or a business partner. So we need everybody's participation so that we know these things are happening. And it was a manager and Brandon, one of the waste management people, who brought this issue to the committee. We didn't know about it. It came from a manager and a business partner. So we really want you all to participate and welcome your participation in the committee, please. So I think we can take some questions if anybody has any. Understand technology is a whole issue here, but we'd be happy to take questions. We can figure out how to have them. So
everybody's still there.
oh, it says there. Okay, I'm gratified to see there's nothing in the chat, because that's a little complicated for me.
Yeah.
But Cameron, if you can stop sharing the screen so we can maybe see the participants, if you guys could raise your hands, we could call on you. All right, and I can only see 8 people at once, so I need you to use the hand raising option in this on Zoom, so that it'll bump you to the beginning of the list, and then we can see that you've raised your hand. Yay! Yay! Okay, Jan has a question.
I gotta unmute.
You're unmuted. You're good.
Okay. With the items that are tabled or delayed, do they come up? Are they going to possibly come up in the longer session this coming year? Are they tabled indefinitely? Just for everybody to know, or does it depend on what it is as to what happens with it?
A couple of these are pretty sure bets to come back, Jan, this coming year. I think you're going to see the ham radio bill will come back. I think the bingo bill will come back, and the conservation landscaping bill will come back. A couple of those others that we talked about, that'll depend on whether after coming out of the Housing Commission, anybody decides. And with David Bulova chairing that group, if he thinks it's worthy of legislation, he may propose it, or he may have somebody else help him out. But most of what we mentioned today as something that died in committee or carried over, you're going to see back this next year.
Is there something that the committee can send out through the chapter regarding these items so that it puts it front and center, in front of the managers, and we can put them in our board packets so that our boards and communities are more aware, so that we start generating some feedback now and some thinking about it, which may help to support what you guys are trying to do on the other side.
Yeah, I think, I think that suggestion is really a good one. And I think maybe the thing to do, and I'm not trying to push it off on the LAC, but I think maybe that kind of an approach, kind of a preseason alert, if you want to call it, whatever the case may be, for the LAC, and they could then address some of these issues kind of well ahead of time, because and we mentioned it earlier, what happens with a lot of this proposed legislation, it'll get considered, submitted, drafted by legislative services, depending upon maybe how it comes out of the Housing Commission or who it is that makes a recommendation. So I think, knowing what we know now, this would be a good thing to pass on to the LAC, and then see if we can't get I would say a statewide distribution on these issues. Yeah. Because usually when you know that there's been carryover and it's coming back, you're pretty sure you're gonna see something. And the problem is, if you wait till January, most of the sausage has been made. And so you've really got these summer months and into fall, and everybody is very focused on campaigns,
Yes.
raising campaign funds for the various legislators. But then, November will come, and then everybody's got to get to work. So I think the idea of getting some of these out on people's, skyline now is a very good idea. And I think we'll follow up on that suggestion.
Absolutely.
Thank you.
Thanks, Jan.
Yeah.
And to build on that, many of us send out weekly notices and stuff to our communities. It's not just for the boards, but it's for the communities as well.
Absolutely.
Send it out, then take it the next step for those that are here, and send it out to your communities. As I said, you never know what ideas come back. The same thing with the trash issue in
Yes.
Fairfax County. Let's get it out to our homeowners, to our boards, so that they start sending in to their legislative people that information, because it's going to create, all of these are going to create some interesting challenges, if you will, pro and con for all of us.
Yeah.
That's just my 2 cents.
Thanks, Jan. I appreciate it.
Amy and Bill, we also have a question in the chat. Linda,
Hold on. Oh, you have a question in the chat? Cool.
Yeah.
Hold on. I can pull it up.
Yeah. I was just going to read for everyone.
More details on the bingo bill. Yeah, we'd love to. No, we don't know what it's trying to accomplish. That's the problem. We're not sure. And, if they were trying to, bingo is gambling. So it's not allowed.
Right.
And so I think what they were trying to do was enable communities to have a certain number of bingo games. And I would suspect that the reason there was a limitation and a donation to charity and that sort of thing built in was because to make it as sweet as possible to pass.
Well, as some of you know, there are bingo games allowed, like at fire stations.
Right.
That's
Exactly.
all under having to deal with special legislation and status and so forth. And so I think they were trying to carve a niche out for the 55 and older community. And this is like an attempt. I think we will see more coming out of what has happened, and then have something else to look at. But we don't have a lot more detail than this.
Though part of the reason it was bumped or that it died in committee is because the gambling commission needs to be in place.
Right.
And it's not. I think that's in process now. So it was kind of like, we could pass this bill, but then there's nobody to then manage it, right? Because there's no gambling commission.
Right.
So they kind of tabled that whole thing so that the gambling commission could be in place first, and then the bingo, issue, whatever it may end up being,
Right.
would be put into place. Does anybody else have any questions or brilliant ideas? I'll take all of it.
Following up
Please.
on what Jan had said, maybe what we can do as a committee is sort of summarize what happened today and highlight some of that, and then we can get that out to our group.
Yeah, absolutely.
Yeah.
The next legislative committee meeting is actually next week, Wednesday at 11:30. So I have 53 people on right now. I expect to see 53 people at the meeting next time, because we need participation to make this work.
That's right.
Do we have any other questions? Like I said, you have to raise your hand the fancy way, otherwise I'm not going to see you.
Are we still being seen?
All right. Well, if you guys think of anything later, anything you want to know about, feel free to email me and Bill. We're happy to try to find out stuff for you or give you what inside knowledge we've got to the extent we've got. Thank you guys so much for coming and spending your lunch with us. We really appreciate it. I hope you have a good rest of your day.